All right, welcome back, everybody, to another deep dive.
Always exciting.
You know, we like to get into the weeds here, and today we've got kind of a tricky one, I think, and interesting for sure.
Definitely an interesting case.
We're going to be looking at Garza v. Idaho. This is a SCOTUS case.
The Supreme Court, yeah.
And it really kind of gets at the heart of, okay, you've got this defendant, they plead guilty, they waive their right to appeal.
Right, part of the deal.
But then they say, lawyer, I want you to appeal anyway.
Uh-oh.
So now you've got this conflict, right? So
Yeah.
that's kind of the big question here. What happens?
What happens, right?
Does the idea that the defendant was somehow harmed by their lawyer not doing what they were told,
Right.
does that idea, that assumption, does it still apply when there's that waiver sitting there?
Right.
And the Supreme Court said, yep, it still matters.
Yeah, it does.
Even with the appeal waiver. So pretty interesting stuff, and we're going to unpack all of that today.
Yeah. I think what's really interesting here is, the idea of finality in the legal system.
Yeah, right.
We want things to end. We want closure.
Right. We want to make sure that it doesn't just go on and on forever.
Okay, exactly. And that's part of what plea agreements are for, right?
Yeah.
And appeal waivers are part of that too. It's like,
Mhm.
okay, we made a deal, let's move on.
Right.
But then you have this other crucial thing,
Right.
which is, the defendant's right to counsel, their right to have an attorney who's representing their interests.
Right. And to make decisions about their case. Right.
Exactly. To make decisions and to have, their wishes respected, their voice heard in the process. So this case really forces us to look at where's the line where those two ideas clash.
Yeah. Okay. So let's back up a little bit, because I think to really get this, we need to understand exactly how this case ended up at the Supreme Court. So we've got this guy, Gilberto Garza Jr. is his name.
Okay.
Back in early 2015, he's in Idaho, and he's got a couple of criminal charges against him.
All right.
And he ends up working out these plea agreements to basically kind of resolve everything.
Uh-huh.
Now, a big part of these agreements, this is key, is that he agrees, Mr. Garza agrees, that he's going to waive his right to appeal whatever happens.
He's giving up that right as part of the deal.
Yeah, conviction, sentence, whatever. It's like, I'm not going to fight it. The trial court looks at this. Everything seems on the up and up.
Yeah.
And they go ahead and they sentence him based on, what's in the agreement.
Okay.
So far, so good, you might think.
Sounds pretty straightforward.
Right. But then it gets interesting because even though Mr. Garza had signed these waivers saying, no appeals, after the sentencing, he goes to his lawyer and he's like, actually, you know what? I've changed my mind. I want to appeal this.
Interesting.
And we know this because it's all in the records. He didn't just say it once. He kept going back.
Oh, wow.
He's calling his lawyer. He's sending letters.
Really making it clear.
Yeah. Hey, remember we talked about that appeal? Let's do it.
So it wasn't like a miscommunication or a one-time thing?
No, not at all. And to be really clear, we know for a fact the lawyer knew what Mr. Garza wanted because he actually swore in an affidavit. He said, yeah, my client told me to appeal.
Okay, so there's no doubt about that.
None whatsoever. But here's the thing. He didn't file the appeal.
He didn't.
The lawyer didn't do it.
So even though he knew and his client kept asking.
Even though, yep. So now we're really getting into the weeds here.
Yeah, we're in the thick of it.
And this is where a really important case comes in from back in 2000 called Roe v. Flores-Ortega.
Okay, I've heard of that one. It's pretty significant.
Huge, yeah. And the Supreme Court really leaned on this case when they were making their decision in Garza. So basically what Flores-Ortega says is this. If a defense attorney messes up so bad, if they're so ineffective that their client loses their chance to appeal, and the client would have appealed if the lawyer hadn't messed up, then we just assume the defendant was harmed.
We presume prejudice.
Right, exactly. They don't have to prove that they would have won the appeal or that their arguments were even good.
The fact that they lost that chance, that's the harm in itself.
Exactly. So that's the backdrop, right? We've got Flores-Ortega saying lawyers messing up and costing clients appeals is bad. We assume it caused harm.
Right.
And then we've got Mr. Garza, who told his lawyer to appeal, and the lawyer didn't, but he also signed that waiver.
That pesky waiver.
Right. So that's the big question.
The $1 million question.
Does that waiver wipe away the Flores-Ortega rule?
Does it change everything?
Yeah, that's what the court had to figure out.
Big implications, for sure.
Now, there were some pretty strong arguments made that, hey, even with the waiver, we should still assume Mr. Garza was harmed.
Okay, I'm curious about those.
And one of the big ones was this. They said, look, There are other situations in the law where we already do this, where we automatically presume prejudice. Like, if someone's denied a lawyer at a super important moment in their trial, the Supreme Court has said that's a problem.
Right. Like that Chronic case. United States v. Chronic.
Exactly. Or if they just have no lawyer at all during an appeal, the court has also said that's no good.
Penson v. Ohio. That was a big one for that.
Right. So the argument is this situation with Mr. Garza, it's kind of like those core Sixth Amendment violations where it's so fundamental you just assume there was harm.
Yeah, because by not filing the appeal, the lawyer basically took away Mr. Garza's entire chance at a direct appeal, which is a big part of how our system is supposed to work.
Yeah, and it really undermines that core principle from Flores-Ortega, which basically said, if a lawyer's bad performance makes you lose your appeal, that's a problem, and we assume you were harmed.
Right. So in their view, it doesn't matter that there's a waiver because it's about the lawyer not doing their job, not about the waiver itself.
Makes sense. So focusing on the lawyer's actions and how that affected the defendant's ability to access the appeals process. Yeah. But of course, there's another side to this, right? The state of Idaho and some federal courts that had looked at cases kind of like this before, they argued the opposite.
So they said the waiver should make a difference.
Big time, yeah. Their main point was, look, he signed the waiver, he agreed to this.
He gave up that right.
Voluntarily, knowingly.
So he shouldn't be able to go back on that.
And they said, if we start saying the presumption of prejudice still applies even with a waiver, what's to stop people from appealing things they specifically said they wouldn't appeal?
Yeah, it could undermine the whole plea bargain system.
Right. And some courts had actually agreed with this idea, and they'd said, no, Flores-Ortega, that doesn't apply when you've got a waiver.
So there was a real split in how this was being handled.
Yeah. So the Supreme Court, they had to weigh these two sides.
Tough job. Right.
And as we know, they sided with Mr. Garza.
Okay. So even with the waiver, they said that presumption of prejudice still mattered.
Right. So what was their thinking? Why'd they go that way?
Well, a few key points really drove their decision. The first one was they said an appeal waiver, it's not like you give up every single appellate right you have.
It's not a total shutout, in other words.
Right. There are still some things you can appeal, even with a waiver. Like, let's say you argue that you didn't really understand what you were agreeing to when you signed the plea deal, or that you felt pressured into it. Those kinds of claims, they can still be brought up.
Oh, interesting. So even with a waiver, there are still some doors open, potentially.
Exactly. So the court was saying the waiver has limits. It's not a blank check.
Okay, that makes sense. And I guess that kind of leads into their second point, right?
Yeah, their second point was all about the client's right to make decisions. They said when a lawyer just ignores their client's direct instructions to appeal, even if there's a waiver, that's a huge problem.
It's like they're overruling the client on a fundamental part of their case.
Yeah, exactly. It's about the client's autonomy, their right to make those big decisions. Even if the lawyer thinks, oh, this appeal's a long shot, the client should still have the say.
Right, because it's their life, it's their case.
Exactly. And then the third thing the court brought up was they were like, look, having a clear rule here just makes things easier.
Practically speaking.
Yeah.
Yeah.
And they pointed out that most of the federal appeals courts that had looked at this, they already had a rule saying if the lawyer screws up and you lose your appeal, even with a waiver, we presume you are harmed.
So the Supreme Court was kind of saying, look, this is already working in a lot of places.
Yeah.
Let's just make it consistent across the board. And they even pointed out that it wasn't causing huge problems or backlogs.
So it's like, let's just put things back the way they would have been if the lawyer had done what they were supposed to.
Exactly. Give the client that chance to appeal. Let the higher court review everything with proper arguments from both sides. That's how the system is designed to work. Right. And I thought it was interesting that they addressed this argument that, well, a lot of appeals that might fall under a waiver probably wouldn't be successful anyway.
Yeah, they basically said that's not the point.
It's not about whether you would have won. It's about the fact that you were denied the chance to even try.
Right. Focus on the opportunity, not on predicting the outcome.
Right. Now, the court also went out of their way to say that this Garza decision, it's not exactly the same as something they'd said in Flores-Ortega. Remember how they'd rejected the per se prejudice rule from the Ninth Circuit?
Yeah.
Well, they wanted to make it clear why this was different. Basically, in Flores-Ortega, they'd rejected that rule because it didn't require showing that the lawyer's actions actually caused the lost appeal.
Like there had to be a direct link, right?
Yeah, a clear cause and effect.
Yeah.
And they felt like that Ninth Circuit rule was too broad. It might sweep in cases where the lawyer's actions didn't really make the difference. But in Garza, they were like, no, here we've got that direct link.
Because the client specifically told the lawyer to appeal, and the lawyer just didn't. It's as simple as that.
Right. So the instruction and the failure to act, that's the cause and effect.
But still clear.
Yeah. So to sum it all up, the Supreme Court said, even if a defendant signs a waiver, if they tell their lawyer to appeal and the lawyer doesn't, we assume the defendant was harmed. That's the rule now. So for our 10th chair segment, we like to imagine we're on the Supreme Court. We get to weigh in on this.
Put on the robe, make the tough calls.
Exactly. So if you were that 10th justice, what are your thoughts?
You know, sitting here in the 10th chair, I got to say, I'm with the majority on this one.
You'd side with Mr. Garza?
Yeah. I mean, appeal waivers, they're important. They help things move along, but they can't be a free pass for lawyers to just ignore their clients.
Right. Like it can't override that basic duty to listen to what your client wants.
Exactly. And we can't forget, like we talked about, these waivers aren't all powerful. There's still some things you can appeal, even with a waiver.
Right. Those very specific claims.
And when a client says, appeal this, maybe they're trying to go after one of those specific things.
Yeah, maybe they think they've got a shot at arguing that the plea wasn't really voluntary or something like that.
Exactly. So if the lawyer just ignores them, it's like, well, they never even got a chance to make those arguments.
And the court was really concerned about that, right?
Yeah. They kept saying this is about the client's right to make decisions, to have a say in their own case.
And I think what you said before about the clarity of the rule is important too.
Oh, absolutely. Having a clear rule, it just makes things work better. Everyone knows what to expect. And it's not like it's creating chaos in the courts. They're already doing this in a lot of places.
So it's more about consistency and fairness then.
Yeah. It's saying, let's treat everyone the same. Let's make sure everyone gets that opportunity to appeal if their lawyer messed up, waivers or no waiver.
Really interesting stuff. So listeners, what do you think? This Garza v. Idaho case, it raises some big questions.
Big questions about how our legal system balances things like plea agreements, efficiency, and a defendant's fundamental rights.
How do we make sure things move along smoothly, but also make sure everyone's rights are protected?
And how much power should a waiver have? When does it become too much?
Yeah, lots to ponder. We encourage you to dig deeper into this case and others like it. It's a complex area of the law, but it's important. Thanks for joining us on this deep dive.
Always a pleasure. Until next time.
See you then.